Namaste, Sakshi Sakshi. I am Priya Gotetti. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need specific legal advice, please contact the attorney directly. So without any further delay, we can start our show. So hi Prashanthi, welcome to our show.
Hello Priya, how are you?
I'm good. How are you?
I'm good, thanks.
Okay, so Prashanthi, before we start, so can you please provide information on your law officers, practice areas and your experience?
My name is Prashanthi Reddy. I'm an immigration attorney. My offices are in Midtown Manhattan, and I have been an attorney for now 24 years. I think I've been an immigration attorney since 1997. And so we specialize in business and family immigration. We have a lot of experience in those areas.
Do you have any update for this week?
There are several, and during the course of the show, we can, go through each of them.
Okay. So before we continue the show, I wanted to discuss about today's topic. It's how to prepare on the H-1B audit. So before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask some tips. So what is this actually H-1B audit?
So H-1B audit really talks about employers being audited. So, but it's not only an employer problem. If the employer is audited, the employees that are in that company will also be questioned, and obviously if the employer is audited, then not good for the employees, because then they'll have to find a new employer if there are a lot of violations that the employer does. So it's important for both employers and as well as employees to know about these H-1B audits. So H-1B audits are conducted by the Department of Labor and the USCIS. So both agencies can conduct an audit. The labor or the H-1B audit can result from multiple causes. It could be employee complaint, embassy, like your employee goes to the US embassy and they find out that there's some issue with documentation there. There's some fraud involved in the documentation that could cause an audit, or it could just be a random audit. So there could be many reasons for why audits are done, basically. So the Department of Labor expects documentation to be submitted when there is an audit. And there are two types of documentation. One is the public access file, which is something that every employer has to maintain. So for every employee, you have to have a public access file. So in that, we will discuss later what has to be in each file. And in addition to that, there is documentation which must be provided upon request. So that is the documentation such as the tax returns, wage reports, etc. But the public access file is something that has to be maintained in the office and it has to be available at a moment's notice. So it's not something you can prepare after. It's something that every employer has to, it's record keeping that every employer has to have. So those are the documents needed for an audit, and that's what an audit is.
So what factors are to be taken into consideration for this H-1B audit?
So you might also ask me why does an audit occur? And we discussed a little bit about that, and then I will come to the factors as well. Audit, 80% of the audits, as I said, is because of employees complaining. So if you don't treat your employee properly, if you don't follow the rules, if you don't pay them on time, they will complain to the Department of Labor Wage and Hour Division. So that could cause your company to get an audit. And if you're an employee, please note that if you don't get paid, you can complain to the Labor Department, and that would result in an audit for your employer, which is not good. So that's one way of kind of making sure that they pay you your salary. So 15% of it is because of consulate referrals, as I was just saying. Sometimes, employers, in order to get an approval, will doctor some of the documents. If there's an end client letter, for example, they might change some information in the end client letter, and obviously the consulate is going to call the client, so it's not a very intelligent thing to do, but sometimes people do it. So if there are some such doctored documents, or if the job is not what they say it is on the LCA, or if the beneficiary is not able to really respond to any of the questions as to the nature of the job, there might be a question as to whether the job actually exists or not. So those are the type of cases that the consulate will refer back to USCIS, and the USCIS will then might start an audit. So that is the consulate referral audits.
Who performs this H1B audit? Is it the USCIS?
Right. So some of them are, again, 10% of the audits are random. So that's your percentage of audit. So who performs the H1B audit is pretty much either Department of Labor, if it is a wage issue, or it could be USCIS, the Fraud Prevention Unit in USCIS, or it could be FDNS, which is a contractor that works for USCIS, that investigates after the approval comes whether the person is working at that place or not. So any of these people could do the audit. And then coming back to the factors, as you were asking me, what factors are taken into consideration during a H1 audit. So whether it be the DOL, the Department of Labor, or the USCIS, they're going to look at whether you paid your employee salaries, or whether you benched your employees. Usually in the IT world, it's something called benching, where if the person is in non-productive status, if they don't have a project, sometimes employers don't pay them. So that is benching. So if you don't pay them, that is a reason for what they're going to look at in an audit. If you got a new job at a different location, your employee got a new job and you didn't file a new LCA, they're going to look into that. Where he's actually working and what LCA do you have. They're going to see if you actually paid the wages for that particular work location. So for example, if you filed a H1 for California and then the person moved to New Jersey, if you're not paying the New Jersey wages, they're going to look into that. And they're going to make you pay the back wages of how many ever months or years that you didn't pay. Also, they want to see if the information that you gave in the LCA labor certification is the correct information or not, with reference to your address, the type of job, the client they're working at, or whatever project they're working on, the job location. So these are all the things that they look at when they do an audit. They also look at if, suppose you, before hiring the H1, you got an employee who was a US worker. So it could be a permanent resident, US citizen, and they were just as good, well qualified as the H1 employee, but you didn't hire them and you hired the H1 instead. They're going to look at that also. So these are some of the things that they look at. And yeah.
So if at all an employer is found that they are violated some rules, is there any penalty that they are going to impose on the employers?
Yeah, Priya. So the penalty is pretty hefty, and nowadays it's more hefty than before. And sometimes they can be a criminal investigation that started, fraud investigation. So we don't want to be in that situation. So always be in compliance. But the penalties can range from 1,000 to 35,000 per violation, per person. So for example, one person, you might have several violations on that person. Failure to pay wages, failure to maintain documentation, etc., etc. You can have more than one violation. So each violation, and if you have 50 employees, then your violations can go into $1 million. So that is the violation. And earlier, 10 years ago, maybe 15 years ago, they would look into everything, but usually they would, if they find that it's not serious, they would let you go with a slap on the wrist. But now they're not doing that anymore. There's no tolerance really for these kind of things. So I guess we need to look at how do they decide what the penalty should be, whether they should impose a serious penalty or let them go off with just a small amount of money or maybe just a warning. So they look into your previous history. Did you ever violate? Did you have any violations before? Was there a DOL or a USCIS audit before, and were you guilty of any violations before? How many workers were actually affected? Were all your workers affected by this violation, or you just didn't follow the rules with reference to one of your employees? How grave were the violations? Was it something that you owed people thousands of dollars and you didn't pay them, or is it just one person you owe them a small amount of money? What efforts did you make to comply with the programs? Look, if you tried to comply and you couldn't for some reason, then they're going to look into that also, that you tried. What your commitment is not to ensure that you don't violate further. Do you have processes in place now to avoid such violations? And also, what was the effect of the violation? Did it give you a huge financial gain, or did it give a huge loss to your employees? If there is no loss or gain, then they might be willing to look at it more leniently.
I just have a question. Like, if employees wanted to know that if their employer has already violated, or do we have any website or somewhere where we can check whether the employer has previously violated or paid some penalties?
Right. There is unfortunately no way of checking that. Unless it's a really big case, then USCIS will publish it
Okay.
in the news, so that other people will be warned. Then, of course, you will know. But otherwise, for every every case that is opened, there is no website, to my knowledge, where you can check whether the employer is in compliance or not.
Okay. So, what are the other obligations that H1B dependent employees can have?
Right. So, as it is, if you are a H1 employer, even if you're not H1B dependent. Now, a H1B dependent employer, for those who don't know, put simply, is if you have majority people working on H1. You're a H1 dependent employer. Now, all employers have to attest to certain, are obligated to do to certain things and have to attest that they have done them. One is that they have to pay the non-immigrant worker at least the prevailing wage or the actual wage, whichever is higher. And they also have to pay for non-productive or bench time, as we discussed earlier. And they have to offer the same benefits on the same basis as US workers. So if a US worker is getting some benefit, you have to offer that to your H1 worker also. There can be no discrepancy or no, then there's unfairness in, you give somebody something and you don't give somebody something else, you're violating employment law as well. So you can't do that. Everybody has to be given the same benefit. You have to provide working conditions for the H1 workers, good working conditions that will not affect the working conditions of your other workers. You have to provide everybody's same working conditions. Like if you're, if the office, whatever it is that you're providing, the desk, the computer, everybody has to be provided with the same working conditions. You cannot employ anyone in a strike or lockout situation. So make sure you don't do that. If there's a strike in any company, you cannot employ a H1B worker there. Also, you have to post the LCA. So there's a posting requirement for the labor condition application. As soon as you file it, you need to post it. Meaning you need to inform everyone that, this LCA is being filed for this employer and this is the salary. So you have to make sure everyone is aware. All your employees have to be aware of what the salary is, what you're offering, and etc., etc. So that has to be done before you file the labor condition application, which is a document that you file before you file the H1. But as you were asking, there are additional rules that apply to H1B dependent employers. There's some additional attestations that they need to take care of. It is additional obligations that they need to take care of. But there's an exception. They don't need to take care of, they don't have any additional obligation if the employee that they're hiring is exempt, which means that they have at least 60,000 salary or they have a master's degree. So they're exempt from these additional obligations. What are those additional obligations? The H-1B dependent employer cannot displace a US worker, meaning they cannot lay off a US worker within the last 90 days and then hire a H-1B worker in that same position. Also, if someone is working at an end client site, the end client also is obligated to do the same thing and cannot lay off a US worker within the past 90 days for the same job. Also, the employer has to do some recruitment, some good faith recruitment, meaning they have to look for, advertise the job. It could be just simple as advertising on their website. And that advertisement has to be open to everyone, to all US workers. And if they do find someone and if they're just as good as that H1 employee, then they have to hire the US worker instead of the H1 worker. So if they find out that they have not done that, then there's a problem. So there's an obligation to do that. So that is basically some of the obligations for a H1 dependent employer.
So, viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesc.com or call 212-354-1010 or visit www.readyesc.com. So, Prashanthi, coming back to the topic, so before you were talking about this public access file, so can you please provide more details on public access file?
Yeah, sure. So basically a public access file is a file that has to be maintained for each H1B employee by the employer. So there are certain documents that have to be put in this file and they have to be available at any given point because sometimes the USCIS or DOI will come without unannounced. They'll make a surprise visit. So at any given time, these files have to be at your work site, at your company, and they have to be available for anyone who asks them. So what does this file contain? So the file contains a copy of the LCA. We were just talking about the labor condition application, which is the first step to file the H1. The copy of the pending LCA or the approved LCA once it's approved. Then it has to contain a wage statement, basically mentioning what the wage it is that you're paying for that particular employee. Now usually the LCA itself will have the wage, but sometimes if you're filing for multiple employees and if it's on one LCA and if there is a wage range, then you have to maintain a separate wage statement mentioning specifically for this particular employee what is the wage. And every time you file an extension or you change something and the wage rate changes, the work location changes, you have to mention the new wage rate and you have to have a letter which says this is the wage rate for so-and-so employee. Then you have to have a memorandum on how you come up with wages, right, in your office. So that's called the actual wage memorandum. So for example, you have to have a memo which says, okay, if it's a systems analyst position, if the person has a bachelor's plus 2 years of experience, this is the wage. If the person has a master's, this is the wage. If they have 5 years of experience, this is the wage. For a software engineer position, same thing again. So the positions that you have in your office and you use often, you have to say on how you pay them. And you have to remember that the LCA already has a prevailing wage. So you have to pay the higher. You have to pay the higher of the prevailing wage or the actual wage, whichever is higher. So for example, if you're paying the prevailing wage to one of your employees, but a US citizen for the same job is getting a higher wage, that is the actual wage. So you have to pay that wage. So that's something to remember. So you have to have that memorandum, that memo as to how you came up with that wage in the public access file. Then you have to have a copy of the prevailing wage document. So when you file a H1, you have to go to the Department of Labor website and you have to check what is the prevailing wage for that particular person and that position, and you have to pay that wage or the higher or the actual wage. So you have to print out that prevailing wage document for each employee that you refer to and put it in the public access file. And now when the Department of Labor, or you can use a private wage survey also, when they come up with a wage, they have a methodology as to how they came up with the wage. So you have to print out that methodology also and have that available for anyone who wants to look at it. Then you have to mention the benefits in that employee's public access file. What are the benefits that are being offered to the H1 worker? For example, life insurance, 401k, health insurance, this many days of vacation, sick leave, etc., etc. And also, you have to, when you're filing the LCA and when you get an approval, you have to give a copy of that LCA. Remember, I said it has to be posted and available for all the employees to see. You also have to give it to the employee, that particular employee, and you have to show proof that you gave it to him. So if you submitted it via email, which is the best way of doing it, make sure you have that email correspondence. Then, in addition to that, you have to have a list of exempt H1B employees. So when you're using an LCA for multiple people, and you're saying that you're using it only for exempt employees, so employees who are over 60,000 or who have a master's degree. Remember we talked about that. So if that is such a person you're using for several people under one LCA, you have to list all those exempt employees for that LCA for each file. And then also, last but not the least, you have to have a recruitment summary. Remember I said that when you're H1B dependent, you have to first recruit and then show that you didn't get anyone and then you ultimately hired this H1. So you have to have a summary of your recruitment. So it's as simple as just mentioning on your letterhead what recruitment you did. Or you can actually print out and put the actual advertisements that you placed, maybe on your company website. So that's so pretty much that's what is required in a public access file.
Prashanthi, suppose if an employee changes the location, so the wage level gets changed, or if he gets promoted, or if the wage level gets changed. So within how many days does the employer has to file, he has to do once again an LCA? If not, he get it's a kind of violation, right? So do we have any time?
Right. So before the person starts working, they should ideally at least file. You don't need an approval, but file the petition before the person starts working. Now there's an exception, a 30-day exception. For example, if you think that initially you thought, so if the work was only for 30 days, then you don't have to file an amendment. You don't have to file a change in worksite petition again. So that's the exception. So if it extends beyond 30 days, then you have to file it. So there's this kind of 30 days period where you have to file the amendment. But otherwise, if you know that it's going to be long term, you have to file it before they start working.
Okay, got it. So what are the H1B visa alternative options?
Right. So now that we have filed the cap is over and people have filed their H1Bs. Now the rest of the year, what do? How do we hire someone in a non-immigrant status, right? That's the question that everybody has. So there are many alternatives to a H1B. Some are more difficult and some are easier. One immediate thing that comes to mind if you don't get selected in this cap is wait for the second lottery to happen. It's likely to happen in July or August because we know that a lot of duplicates were registered. So one employee's filed, several petitions. So they can only file one petition. So the rest of the petitions won't get filed. So it's likely that the lottery will be run a second time, and some people might get lucky in that second round. So that's something to wait for before we do anything. The second thing is if you're a cap exempt organization, Or if you're working for a client who is cap exempt, then you can still file the H1. You don't have to wait for next year cap. So who is a cap exempt employer? An institution of higher education or an organization that is related to an institution of higher education and is a non-profit organization, or a non-profit research organization or a government research organization. So either higher education or research organization. If you're one of those, then you are exempt from the cap, 65,000 cap, and you can file at any time. Or if you are an IT person and your client is one of those organizations like a university, right? Or a hospital, teaching hospital, which is attached to a university, or some kind of a research organization, then you don't have to wait for the cap. You can file at any point of time. The other category is the O1 category, the extraordinary ability visas. So O1 often, the problem with this is that you have to show that the person has extraordinary ability. It could be in the sciences, in the arts, education, business, television, motion picture. It can be in any of these things. So it could be in IT also. But you have to show that they have extraordinary ability. So this is not for everyone. This is only for people who are really good with what they do, because you have to show proof that they are good. Maybe they have their own patents. Maybe they have awards. They've developed their own software. Somebody like that would be a great candidate for O. Or they've done wonders in the field of business. They've been featured in magazines. So some of these people, it's possible you can get as an alternative to the H. You can get them on an O. The more viable option, though, is an L1, because an L1 and a H1 are very close to each other. Now, for example, if you have a person in India who you're trying to get to the US and you file a H1 for them, but it doesn't get picked. If they're working in India, and if they've been working for the past 1 year in an executive position or in a specialized knowledge position, you can file then an L1A or an L1B. And the benefit of an L1 is if they come on an L1A, they also get into an EB1 category, and therefore they can get their green card faster. Right now EB1 is current, so you can get your green card immediately. So an L1 is a really good place to be and a really good visa to use, but the only problem is that the person should be working either in an executive position, that means as a manager level position, or the person should, in an L1B situation, the person should have some specialized knowledge that others don't have. So for example, some specialized knowledge of your client or the project or some processes or some product that you use in your company that it's not easy to train anyone else on. In that situation, it would be good for an L1B. Executive is if you're a managerial level, and you're managing other employees, you're an executive level. So L1 is a good fit for those kind of people. The other option is TN. TN is good for people from Canada or Mexico. Again, great for the IT industry, because there is, so the way you qualify for a TN is if you fall under one of those NAFTA positions, and that NAFTA list of positions that qualifies on the internet. So if you fall under one of those positions, you qualify for a TN. So if you're a Canadian or a Mexican citizen, you qualify. So for the IT positions, systems analyst qualify. So, most IT positions, you could use a systems analyst and qualify. So that's a great option if your employee is a Canadian or Mexican citizen. Also, if you're from, there's some country-specific visas. For example, the E3 visa is for Australian citizens, and it's again the same requirement as a H1. You have to show that the position is a specialty occupation, and there is no cap. It's not subject to any limitation. Any number of people can file for the E3. The other one is the H1B one, which is basically people from Chile and Singapore. So again, same requirements as a H1. So there's 1,400 visas available every year for Chile and 5,400 for Singapore. And so if you qualify for a specialty occupation, you can file for a H1B1 if you have any employees from Singapore or Chile. And you have to show the same, that it's a specialty occupation, bachelor's degree is required for that particular position, and you will be able to get a H1. And since even though the visas, there is a cap for these visas, usually that cap doesn't get used up. So, these visas, H1B1 is usually available throughout the year. Now, last but not the least is the F1. If you file for a change of status, the person is on an F1 and they didn't make it to the cap, they can get an OPT, optional practical training, and they can still continue working for you. Or if they're presently completing their courses, they can get CPT, which is curricular practical training, and they can work for you and do their courses over the weekend. So an F1 is again a good option. And the STEM OPT, people from the STEM fields, you get it for 3 years. So that's a good amount of time for a person to work in the US. So that is possible also, the F1. So I think those are the alternatives to the H1.
Thanks, Prashanthi. Since H1 and L1 are very close to each, both visas are similar visas. So this kind of wage limit or wage rules, is it applicable for L1A executives or L1B specialized knowledge visas?
Yeah, that's a good question. The stringent rules that are applicable to H1 for some reason are not applicable to L1. Though so many times they've tried to change the rules. And also there's this pushback, right, with all the multinationals, TCS, Cognizant, that they're bringing people on L1 and they're paying them in India because you're allowed to. So they're actually undermining US workers. But I'm surprised people go after the H1 category, but there's nothing being done to reform the L1 category because there is no minimum prevailing wage that has to be paid. You can pay the person in India. So it's much cheaper to bring someone on an L1 and you can pay them less than what you would pay someone here. So that's an interesting observation with reference to the L1 category.
Okay. So when a person comes on a L1 visa and if he wanted to go on a H1B with a different employer, can it still happen and the employer wage limit and all, because we were talking about all these audits and all. So will it be a problem because the candidate is already on a L1 visa, but he wanted to move to a H1 with a different employer?
So you simply have to file a change of status from L1 to H1. And of course, since we're talking about the cap, he's cap subject. So you have to wait until the cap opens up in March of every year and you have to file register during that time. And only if you get picked in the cap will you be able to actually file the H1 for that person. This is for all change of status applications, including L1 to H1. So you want to avoid being on a H1, but the L1 is only for a certain amount of time, and sometimes you may not be eligible for the L1 anymore if you're not working for that multinational anymore, and you have another employer, but you may not be eligible to file an L1 with that other employer, because remember, you have to work for 1 year first at that employer's foreign location to be eligible. So unless you leave the country, you will not be. So the only option may be at that point for you, unless you want to leave the country for a year and work with that foreign employer at the foreign office, would be a H1.
So how long is H1B Cap Exemption valid?
A H1B extension is, you can get the H1B for 3 years. And then you can file an extension further for another 3 years. So you can stay a total period of 6 years on a H1. But after that, you can continue to stay, and you might need to stay because, even if you file for a green card, because of the way visa numbers are, because of the unavailability of the visa numbers, you may not be able to get a green card for the next 10, 15 years. So there is a provision in the law that if you have an approved I-140, or if your labor has been pending for more than 365 days, you can get further extensions on your H1. So if you have an approved I-140, you can get a further 3-year extension. And you can continue getting 3-year extensions as long as you have an I-140.
So is even the H1B transfer is also a cap exempt?
Yes. So once you count it towards a cap and once you start working on a H1, then for all subsequent cases, they become cap exempt. You're only counted towards a cap once.
Okay. For example, if a person completes like 6 years of his H1 maximum term limit, so his green card is not yet filed. So does he has to go back to India for 1 year, then come with the new H1, or how it would be?
Yeah, right. So that's one more way of doing it. For example, if he has not filed that I-140 or he's filed it, but it's not approved because it's taking time, because he waited until the last minute to file it, or whatever the situation might be, the employee might find himself in a situation where his 6 years is expiring and he does not have an I-140 approval in hand. In which case, then he can leave the country and he can either come back after a year, because he gets a fresh 6 years after 1 year, a fresh term. But then he is subject to the cap again. That's the exception to that cap thing. So he's again subject to the cap after 6 years if he stays outside the country and is applying for a fresh 6-year term. Or he can just wait for that I-140 to get approved, stay out of the country, and then once it gets approved, file for a H1 based on the I-140 approval, not a fresh 6-year term, but 3 years based on the I-140 approval. So in that case, when he's filing based on the I-140 approval, he is not cap subject. He's cap exempt. But if he's waiting for 1 year and then he files, then he is, since he's getting a fresh term based on stay out of the country for 1 year, he is cap subject.
So just a follow-up question on that, Prashanthi, the person already completed his H1 and he's back in India and he filed a new H1 and he came to USA. Then the previous I-140 got approved, but right now he's on a new H1. So will it be a problem to his green card or anything?
So the I-140 approval doesn't have to be from the employer that's filing his H1. It can be any employer. I-140 approved through any employer. And also, it doesn't matter even if that I-140 is then revoked by the employer because he's no longer working there. So now the scenario is that he had a H1 through one employer, he had an I-140 through that same employer A. Then the employment got over, he left the country. That I-140 got approved, but now employer B is willing to offer him a job and file his H1 while he's in India. So employer B can use that I-140 from employer A, which is approved, and then bring him back with additional 3 years based on what we discussed earlier.
Yeah, got it. So how long will this H1B cap exempt process will take? The processing time will take?
The same processing time as a H1 transfer or extension or whatever. It's the same processing time. The only difference is right now, they keep changing the rules with reference to premium processing. So usually what they do in the beginning of the season is they remove premium processing for H1B cap cases because they get so much volume otherwise and they're not able to process them all premium. So usually last year in the beginning of the season, they removed the premium processing for cap cases and then they reinstated premium processing towards the end when things were more manageable for them. So just because of that, it could take a longer time because then you have to wait for that whole regular time processing, which is about 4 months, 5 months. Whereas for a transfer or an extension, you can file premium processing and that nowadays that that is extended to 30 days. Premium processing used to be 15 days, but now it's 30 days.
So viewers, if you have more questions and if you wanted to have a consultation with Prashanthi, you can email at prashanthi@reddyesc.com or call 212-354-1010 or visit www.reddyesc.com. So coming back to this, initially when we spoke about the H1B audits and all, so the main thing was on the wage. So is there any minimum wage limit that the employers have to take care or any other things that the employers have to be obliged with the wage according to the wage?
Yes, so as I was saying previously, but people may not understand it unless they know how this H1B process works. So for whenever you file for a H1, the first thing you need to do is file something called an LCA, Labor Condition Application. That form is filed online with the Labor Department. So when you file that, you have to find out first what is the prevailing wage for that particular position in that particular area. So you can do that in many ways. You can use a private survey. There are many surveys available. You have to use one of those surveys. Mostly people use the Department of Labor wage survey. Now, if you go to the FLCA data website, all the wages are in there. So you just have to choose the right county, choose the job, and then choose the wage level that you want to give them. There are 4 wage levels for every job, level 1 to 4. Level 1 is for people who have less experience or who are just starting off in their job. And level 4 is for the most experienced people. So you can choose, usually if you use level 1, USCIS doesn't like it and sends RFEs. So I usually ask people to use level 2 or above. So once the wage level is found, which is available, as I said, on the website, you have to put that into the LCA and you have to file that LCA with the Labor Department and it has to get approved. Once it gets approved, then that same wage level has to be mentioned in the H1, and then when H1 gets approved, the I-129 and the H1 package, when that gets approved, then that's the wage that you have to pay your employees. If you go below that wage, then you're subjecting yourself to audits, and that's what they look at when you're audited.
Okay. So if I understood correctly, if they are same experience with same level of knowledge, you guys are there, so the employer has to pay the same wage level.
Correct. Yes. Yes. So then we are coming, that is what the actual wage means. So they have to compare what is the actual wage versus what is the prevailing wage. If the actual wage is less, then they pay the prevailing wage. If the actual wage is more, meaning they have to compare what they are paying to other similarly situated employees, then they have to pay the actual wage. A lot of employers don't know that, and they just blindly pay the prevailing wage, and then they end up going into audit, and then they have to pay back wages for several months or several years for every single employee because they didn't follow the proper system.
So sometimes we hear that the employees are blacklisted. Is it because of this audit?
Yes. Could be many reasons, but yes, the audit is what causes the employer. That's how they investigate fraud.
Mm-hmm. Okay. So right now, if a person got H1B and if it's in India, so when is this US consulate gets opened for the H1B stamping and all?
Right. So going to that topic that we need to cover, the consulate issues, right? So there's a lot of updates with reference to recent updates with reference to consulates, and it's important because we have to the H1 season, as I said, H1s have just been filed, and employers are looking to bring those people whose H1s have been approved into the country. So Delhi Consulate has started, is offering all services. So they're offering non-immigrant as well as everything they're offering. That's the only consulate where all the visas are being processed. So obviously there's a backlog at Delhi. So make sure if you need a visa appointment to do that well in advance because they have limited availability. Now Mumbai Consulate was starting to do schedule appointments for all kinds of visa interviews, but now as of April 9th, last week, they stopped simply because, again, there's a COVID cases have risen in Mumbai, so they are gone back to essential services. So now they're only doing essential services, Dropbox, and expedited cases. So they're not issuing any visas. So that's one update. The other update is that the travel ban that all of us know about. There's a presidential proclamation issued by Trump, whereby if the person was out of the country, a non-immigrant, they could not apply for a visa. They could not come into the country. So that ban expired as of March 31st, and the Biden administration did not extend the proclamation. So that's good news. So all kinds of it's business as usual as soon as consulates get back to normal. So you no longer have to be part of an exception. You can attend in person or Dropbox stamping. You don't have to be. Previously, you could only attend these interviews if you came under one of the exceptions. There were many exceptions to that proclamation. Or if you are a member of the Chamber of Commerce. So you don't need to be any of those things now. You can directly go and apply for appointments. That's a good thing. With reference to regular appointments, the rest of the consulates are not yet open for regular appointments, but we are hearing that they are opening up very soon. So not just Delhi, now Mumbai, Chennai, Hyderabad, Kolkata will also be opening appointments for employment-based cases. They're going to have a few slots at a time. So we should, just keep that in mind and stay alert and keep checking the websites for appointments. Also there's the visa fee that has to be paid because of the delay in getting appointments. They have said that fee, even if you pay it now, it'll be good until September of next year. So, they are extended the validity of that fee. So you will not lose your fees simply because there's a delay in getting an appointment. Also, one very important update from the consulate is the Dropbox. So for all those who don't know, if any case that is an extension, the interview can be waived in order to get a visa, and you can simply put your passport into the Dropbox, and if they find you eligible for a visa waiver, they will waive your appointment and do everything internally and send you the stamped visa and passport by mail. This is a great facility. Earlier it was available only if your visa expired within 12 months. Then they extended it to 24 months, 2 years. Now, recently, as of March 11th, they have extended it to 48 months, which means that you're eligible for Dropbox facility and waiver of interview if you have if your visa expired within the last 4 years. So most extensions are eligible. People filing extensions are eligible for this really, because nobody nowadays stays without traveling for more than 4 years. So 80% of the people will be eligible now for Dropbox if it's an extension. Coming to emergency visas, if you can't find a visa slot because of all these issues, COVID, etc. But if you have an emergency situation and if you meet the criteria, and the criteria is on each website, you can request for an emergency visa appointment at any of these consulates. Now keep in mind, previously they were issuing more emergency visas, appointments. Now they've slowed down a little bit because they have so much volume. So now the wait for an emergency visa appointment is over a month. So just so that you have the proper perspective of how long it takes. With reference to administrative processing, now 221G, a lot of you would have heard of this 221G. This is basically if your visa is refused and it goes into further investigation. They don't give it to you at the time that you go for the appointment. They have stopped all 221G cases. They're not looking into them. They don't have the staff to look into them. So if again there's an emergency, you need to request them to look into it on an emergency basis and show that what the emergency is. Otherwise, pretty much it's gone into oblivion that 221G. You should find other alternatives to come into the US. Maybe get a new visa appointment, refile your H1, come some other way, and convert to a H1. Whatever is needed. With reference to whether visa appointments are being cancelled or not, most cases are going as scheduled, but there are some cases that are getting cancelled due to COVID. But on the whole, a majority of the cases are being processed. So another update on the visa stamping is just as there was a presidential proclamation, Trump made a proclamation for non-immigrant visas, he also banned immigrant visas. So the green card visas, people who are waiting outside the country for family-based green card, employment-based green card, those that are pending outside the country. Those have just started opening up because that proclamation again has been lifted on February 24th by the Biden administration. And we've heard that the US Consulate in Mumbai is starting to send out letters and reaching out to the pending cases that they have in the chronological order. It's going to be a slow process because they have, as you can imagine, quite a lot of backlog. I think that's, Priya. Yeah.
I think we have one caller. So we'll take the call and we'll come back to the topic once again. So Raju from Texas. Hi, Raju.
Hey, hi, Priya. Hi, Prashanthi garu. My
Hello.
question is related the H4 and the OCI card. I have got my H1B approval last September, and H4 is still pending. And I guess to apply the OCI card, my wife also should have a visa, right, ma'am?
So, right. So, why do you need a OCI card if you're an Indian national and you have a passport?
No,
You have
not
Indian
for me.
passport?
We have a kid who was born in US.
Oh, okay. I was
and he's been
confused
1 year
as to
old.
why you're asking about OCI when you're
No,
on
sorry.
H1.
Okay, maybe my question was wrong. Yes, I'm sorry. So
Right.
we have a kid 1
So,
year old, and she wants to go to India, but because we have not taken OCI card because of the COVID situation, we dragged for the passport, and he has his US passport. But the thing is, when we are trying to apply for the OCI card online, it says both the parents, if they're living together, both should have a valid visa. And my wife doesn't have a visa because she's currently on the receipt from this January.
Right,
And
but
we
she's
don't
in
know
valid
when she's going to get.
status. She's in valid status because she has a pending status. So you can submit the receipt. Also, something to note, the Indian Consulate, because I work with the Indian Consulate as well. I'm their consular. So the Indian Consulate is not allowing people to travel on a visitor's visa. So you can't travel to India on a visitor's visa, and if you have it, so you're doing a good thing by applying for the OCI, because right now only OCI holders or Indian nationals can travel to India. You must already know that, but I just thought I would, give that information out to people who don't know. But in your situation, the fact that you have a pending H4 is status in this country. They should accept that.
Friend who was trying applying, and I also was looking into it, but they were saying both wife and husband should have valid visas with an approvals.
Right, but
to
it's
apply
not
for the
like
OCI
your
card.
wife is out of status. She is in pending status, and that is a status by
She's in
itself,
pending status.
as per USCIS.
Can because you have some, you are working with Indian consulate. Can you help this case, ma'am, applying the OCI card? Does your firm does it applying for the OCI card?
No, we don't. We actually do US immigration for them. We don't do OCI work. I'm just telling you based on the information that I have, really.
Okay, fine, ma'am.
Yeah.
Thank you. So you want us
You're welcome.
to apply with the pending receipt, right?
That's correct. That's what you should do.
Okay. Oh.
Yeah. Thanks, Raju, for calling. And we have another caller, Manoj from Atlanta. Hi, Manoj.
Hey, can you hear me well?
Yes, we can.
Ma'am, I have a question. I have an I-140 approval already, and I changed my employer. now with the new employer, they want to send me an assignment to India and Malaysia for about 8 to 9 months. So, and meanwhile, in my 7th or 8th month, my H1 visa will get expired too. So, what option do I have then? If I go, that means if I go for that many months, I am out of status. So, can I do? My employer has to apply for extension, and then I have to do visa stamping and come, or I will out of status or what?
Yeah, so correct. So you have to remember one thing, you're not out of status when you're outside the country. There is no question of being out of status if you're not in the country. So whatever period you have remaining on your H1, the clock stops, right? So it's not counted on
Right.
as you being in the US on a H1. So that's 7 to 8 months, you gain it back because you have not used that 7 to 8 months. So you're not, so as long as your I-94 is not expired, of course, if your I-94 expires, then you'll have to file for a H1 beyond the 6 years, and you can based on your I-140 approval. So if the
my
I-94 or
I-94 will get
797,
expired.
right, if it's
Yeah,
going
they
to
will
expire, and if you're out of the country, then you have to file, well, you have to file a H1 consular processing. You can't file an extension since you're not in the country, but that doesn't make a difference from your point of view. You can still apply for the drop box. Sorry, you don't have to go for in-person interview. You still qualify for a drop box because you previously had a visa, which unexpired
Yeah, so the
visa, which
employer
expired less
doesn't.
than 4 years ago.
Yeah, my visa expired 5 years ago actually.
Oh, 5 years
So
ago,
I'm
then you're
on.
out of luck.
Right.
I was just saying a
I knew I
majority
have to
of
go for
people can benefit, but it looks like not. So you just proved me
No, mine
wrong.
is
So
5 years.
yes, yeah, it's 5 years, then you'd have to go for an in-person interview. You won't qualify for
Yeah,
Dropbox.
that's okay. But on the basis of what document? On the basis of my
You'd have to
employer has to
file a
give
new
some
H1.
documents
Your
to me.
employer will file a new H1 for you, consular processing on the basis of that document, and you're cap exempt, so it can be filed at any time. On the basis of that document, you will go, the new approval, I-797, you will go to the consulate.
Yeah, thank you so much, Manoj, for calling us, and thank you so much, Prashanthi, for clarifying a lot of questions on H1B Cap Audit and all of your questions. So if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@reddysq.com or call 212-354-1010 or visit www.reddysq.com. So we'll be back next week with more interesting topics. And this is Priya Koditi signing off. We are watching Sakshi. Thank you.
Thank you.